Okay, so assuming you have something that looks like it is deductible with authorization, then you need to worry about getting the proper authorization, and there are parameters for that. You do need a written agreement. Doesn't mean it needs to be a formal contract per se, but there needs to be some writing between the employer and the employee or the union. So you can authorize these deductions through a collective bargaining agreement with the union on behalf of the employees it represents. The regulations do specify that the authorization has to be in at least 12-point font. So, maybe double check, or at least if you're using these forms going forward, see if you really have 12-point font, because again, that is a relatively new regulation, at least in the last decade, probably. So if you have older forms or just never knew that was a criteria, then you might want to update that. The authorization does have to be express, written, voluntary, and informed. So what does that mean? Well, obviously it has to be written, express. I mean, that's to specifically say this is what is authorized. Obviously it has to be voluntary, meaning you can't hold a gun to the employee's head. Figuratively, that is. Hopefully nobody would do that literally just to get an authorization to take money out of somebody's pay. And informed means the employee is provided with written notice of all the terms and conditions of the deduction, its benefit, and the details of the manner in which the deductions shall be made. Let's break this down a little bit. So you have to, in the authorization, or with the authorization at least, put in writing what is going to be taken out, how much, how often, what it's for, and it has to be one of those items that we've already discussed. Again, this is for the voluntary deductions. You wouldn't need this to take out federal or state income tax withholdings, for example. The employer then also has to provide a notice before any change in the amount of a deduction or a substantial change in the benefits of a deduction. The wording on this in the statute and the regulations gets a little complicated. Arguably, if you didn't give notice because you're taking out 12 cents less than you were before or something like that, then I don't think it's a big deal. The notice requirement is more specific, that before you increase the amount of any deduction, you have to give advance notice. Otherwise, you have to give notice as soon as practicable, which arguably might be with the paycheck, for example, in which the change is being made. Most typically, if you're taking deductions for health insurance or something like that, you're notifying the employee up front. They know what they're getting themselves into. They're either changing their health insurance, or you've told them that the rates and contributions will change. But again, this is something you have to do for any deduction that you're going to make a change to. The other requirement is that the authorizations be retained for at least 6 years after the respective employee's employment ends. I don't know whether anyone has a careful enough retention policy that they're going to then destroy such documents on the 6-year, 1-day mark after somebody's employment ends. I would just say make sure you keep them for as long as you reasonably can, or as long as you keep the personnel files, for example, or any pay compensation related files for employees, and assuming that's already at least 6 years, because that is the statute of limitations for most of the New York labor law, wage payment, minimum wage, and overtime types of requirements.